All right, good afternoon, everybody. Thanks for joining our webinar today on healthcare directives and advanced care planning. Advanced care planning is a process that supports individuals at any age or stage of health in understanding and sharing their personal values and preferences regarding their future medical care. The goal being to help ensure that people receive medical care that's consistent with their goals and values. So this planning requires good communication between individuals, their family, and their healthcare providers, and their considerations for each options. So today we're hoping to give you an understanding of some of the most common healthcare directives so you can start planning effectively for yourself or for your family member, or start thinking about these things if you haven't already done so. So let me introduce who's going to be speaking today. Next slide. So first, we are Disability Rights New Jersey. We're the designated protection and advocacy agency in the state of New Jersey. We have a unique federal authority to monitor settings where individuals with disabilities work, live, and receive services. We investigate complaints of abuse and neglect. We provide legal representation and legal advocacy services to individuals with disabilities whose complaints fall within our priorities. And we participate in outreach activities, provide information and referral, and conduct educational trainings, such as this one, to people with disabilities, their family members, and other professionals, advocates, and attorneys. I am Jill Hogle. I'm the managing advocate of our community inclusion team. I will be our MC for today, along with Mike, who you heard at the beginning, providing our technical support and assistance. And speaking today on this topic is Gwen Arlowski, who is the Executive Director of Disability Rights New Jersey. I can no longer say the new Executive Director of Disability Rights. And we have Michael Brower, who is the supervising attorney on our community inclusion team. Okay, next. And we're very happy to be joined on this webinar by Ryann Siclari. Ryann is a senior staff attorney with Central Jersey Legal Services with a special focus in health law. Central Jersey Legal Services is a nonprofit law firm providing free legal assistance in civil matters to low-income residents of Union, Middlesex, and Mercer County. Central Jersey Legal Services handles landlord-tenant matters, consumer issues like scams, bankruptcies, and family matters including custody, support, domestic violence, restraining orders, divorces, health-related matters including Medicaid, Medicare, and SSI private insurance. Okay, next slide. Okay. Here's where I'll quickly plug DRNJ's COVID website. We're proud to announce that we are the recipient of the COVID-19 Emergency Community Law Grant from the New Jersey State Bar Association for our work on this website. Here you can find information about all the advocacy and the activities that we have been undertaking during this time. There's lots of important resources on this page, including frequently asked questions about specific topics such as the stimulus. There are links to all the replays of the virtual town halls and webinars that we've been hosting. Two important things I do want to point out on this site that are of relevance to today's topic are our advocacy efforts around the issues of allocation of critical care resources or medical rationing and hospital visitation policies. Both topics we have a wealth of information about and have done significant advocacy around. You can find all of that information on our website, so I encourage you to check it out. Okay, next slide. So here's our agenda for today. Gwen is going to be speaking to you first on advanced directives and healthcare proxy options. We'll then turn it over to Michael, who will talk to you about POLST forms or practitioner orders for life-sustaining medical treatment. And then Ryan will round it out talking about designating temporary guardians for children. So Gwen, if you're ready, we can go ahead to you.
Great, thank you for the introduction, Jill, and welcome to all our webinar participants. Can I get the next slide, please, Mike? So while he's switching that, I just want to say again that here at DRNJ, we're really trying to do our best to provide the most up-to-date advocacy and information. And with this COVID-19 emergency, we thought that information about advanced planning relating to healthcare and care of our minor children seemed particularly timely and important. And I know Jill already said it, but I want to take just a quick second to thank Ryann from Central Jersey Legal Services for participating today. I really appreciate her presence, and I have a warm spot in my heart for Central Jersey Legal Services. So check out their work as well. So up front, I want to say that conversations about end-of-life planning, they can be really difficult even during the best of times. And I think in this COVID pandemic, even more so. So I'm going to begin by talking about our statute and get sort of technical, but I want us always to be mindful that these are really important and difficult conversations, and that we need to have sensitivity around this subject. So our law in New Jersey is called the Advanced Directive for Healthcare Act. It was enacted in 1991. So our first question, I think, is what is an advanced directive? First of all, it is a written document and it has to be executed. That means signed and witnessed according to the rules of the statute. I think it's also important to note that an advanced directive can have two different components. It can have a proxy directive, which some people call a medical or a healthcare power of attorney. And it can have an instructive directive, which some people call a living will. And under our New Jersey law, it can have one or the other or both. The choice is really yours. I want to talk a little bit about the difference between these two pieces. I'm going to actually start with an instruction directive or the living will. That's a written document that provides instruction and direction regarding your wishes for healthcare in the event you lack capacity or the ability to make a particular healthcare decision. And the directive would spell out the treatments you want or you don't want in those situations. If you're unable to speak for yourself, if you're terminally ill, if you're permanently unconscious, by way of example. And so in effect, what a living will is doing is saying, please follow these instructions, please follow these directions. This is what I want. It's also important to note that a living will is really relatively limited. It usually only applies in end-of-life situations, and standard instructions tend to be general. It's next to impossible, honestly, to anticipate every future medical scenario when writing an instruction directive. The other component is the proxy directive or medical power of attorney. And this is a written document that designates a person to serve as your healthcare representative. That's the technical term in the statute, but you can also think of that person as your agent. Should you later lack the ability to make a particular healthcare decision yourself. And you can give your healthcare representative as much or as little authority as you wish to make healthcare decisions. And the important thing to note that these decisions are not just limited to end-of-life situations, but the agent has authority in other situations to weigh medical facts and circumstances and interpret your wishes and make decisions accordingly. So this sort of the takeaway on this is that a healthcare power of attorney is really broader and more flexible than a living will. But again, a comprehensive healthcare directive would combine both the living will and the healthcare power of attorney into one document. Before we go on to the next slide, I just want to note that there are some limitations on who can serve as your healthcare representative. Generally it can be anyone you want, your spouse, your children, a parent, a friend, your doctor, a member of the clergy. It can't be your treating physician, but it can be your doctor. But there are some classes of individuals who can't serve. For example, an administrator of a healthcare facility like a nursing home, unless you're related to that person. In addition, you can also appoint an alternative healthcare representative, but it's important to know that only one person can serve at a time. Next slide. So this slide is the who, when, where, how of healthcare directives. So first of all, who can execute an advance directive for healthcare? Well, under New Jersey law, any adult who has mental capacity can execute a directive. And you can do this at any time. What I would say normally to clients in regular times, so to speak, I would recommend that all adults over the age of 18 have an advance directive, and that you should revisit it. Some people say every 5 years, some people say when you reach a new decade, so when you turn 20, 30, 40, so on and so forth. It's also important to revisit when you've had a change in circumstance, like birth of a child, marriage, divorce, other situations where you have a change in circumstance, a new diagnosis, decline in your health care, something like that. And I would say that certainly in this time of COVID, it would be prudent to exercise an advance directive or to revisit the directive you already have. So how do you execute an advance directive? Well, it has to be in writing. You have to sign it and date it, or it can be signed and dated at your direction if you're unable to sign. It also has to be witnessed by 2 adults who can attest that you are of sound mind, free of duress and undue influence. And it's important to know that your designated healthcare representative cannot act as a witness. Alternatively, you can have it signed by a notary or an attorney. I wanted to say something about the where, because these are challenging times with COVID, so the where is a little different than it would be in non-COVID times. Presently, having a witness or notary sign would be a challenge because of social distancing and PPE and all those other concerns. So our legislature recently enacted a statute that allows for the remote notarization of documents, and so notaries, attorneys, and others authorized to do so can use technology like video or audio in order to notarize a document. It's important to note that that law does not apply to witnesses. So if you used 2 witnesses, they still need to sign in person, but taking measures for social distancing, PPE, so on and so forth. Next slide. So when is your advance directive operative? That's the technical legal term. In other words, when is it effective? Well, the first thing to know is it's always springing. That's a legal term. You may be familiar, some of you may have durable financial powers of attorney, and they're generally operative and effective upon signing. In other words, the agent can start to act on your behalf, even if you have capacity, though of course they have to do that at your direction upon signing. That's not the case with an advance directive. It only becomes effective when it's given to the doctor or the healthcare institution. Well, that kind of makes sense, right? People can't follow a directive if they don't have it. But there also has to be a determination that you lack capacity to make a particular healthcare decision. And that determination, whether or not you have capacity to make a healthcare decision, must be done by the attending physician. And then the attending physician would note that in writing in your medical record. And then it would need to be confirmed by another doctor, also in writing, and also made part of your medical record. I want to point out that there is a provision in the law that says that under certain circumstances, that second doctor confirmation is not required when your lack of decision-making capacity is apparent and the attending physician and healthcare representative agree that confirmation by a second doctor is unnecessary. There are also some special rules if the individual lacking decision-making capacity lacks that because of a mental or psychological impairment or developmental disability. In those situations, the confirming physician has to be somebody who has specialized training in those areas, and they too have to do it in writing and make it part of the medical record. A couple quick points on revocation and lack of capacity. Once you've executed an advance directive, whether the proxy or the instruction or both, you can revoke it, and you can either do that orally or in writing to the healthcare representative or the healthcare professional. Or you can execute a new proxy directive, instruction directive, or both, and give it to those individuals. In addition, if you lack capacity, you may suspend an advance directive, and you can do that also orally or in writing. And that's a slightly unusual thing in the law, and I'm not sure many other states have that, but New Jersey does. So you can say, I may have written in the past that I didn't want a certain kind of life-sustaining treatment, or I did want a kind of life-sustaining treatment, and now I've changed my mind. So you can revoke that, and you can also actually reinstate it. So a lot going on there. Next slide, please. I'm going to cover this slide very quickly. And I actually include this here because of conversations I've had with my mother, who's 88 years old, and repeatedly tells me that, you know, she doesn't want any life-sustaining treatment in any situation. She's lived a really good life, and that's what she wants. And I have to remind her that I don't have that authority as her healthcare proxy, because limitations on withholding or withdrawing life-sustaining treatment are limited under the New Jersey law to these 4 situations: terminal conditions, permanently unconscious, the life-sustaining treatment is experimental and not proven therapy, or is likely to be ineffective or futile, or merely prolong an imminent dying process. And then there's a last category that looks at whether or not the condition is irreversible and the burdens outweigh the benefits. Next slide, please. So before I end, I just want to touch quickly about some thoughts about approaching the process for writing your own advance directives, and echoing what Jill said at the beginning, you know, thinking about your values, your goals, and your priorities, and making sure that they're reflected in your advance directive. So I think it's best to begin with a period of reflection, thinking about what you want in an end-of-life situation, who you think would be a good decision maker for you, someone you think would respect your perspective and your wishes and would make a decision as you would make a decision. Also important to reflect on the importance of making your healthcare wishes known to others. These are very hard conversations. And in the last slide, I'm going to give you some resources where you can read about ways of thinking about this and approaching the conversations. And right now, it may be a good idea to do some thinking and researching about your decisions and wishes should you get COVID-19. This is really tough stuff to kind of confront, but there are certain things particular about this illness, especially with respect to ventilators, that you really might want to think through and make an informed decision for yourself, and then convey that in an advance directive. You also might want to think about the kinds of treatments you may or may not want. For example, if you can't eat or drink, do you want artificial nutrition or hydration? If you can't breathe, do you want to go on a ventilator? If your heart stops, do you want CPR? And there are a lot of other important decisions to think about. Next, it's important to have those conversations. This is self-evident, but you'd be stunned by how many people don't even tell their proxy that they've appointed them the proxy, and the person doesn't find out until a situation arises and the directive goes into effect. So it's important to have those upfront, and when you execute the directive with the person you appoint, with your family. I can't emphasize enough, especially the children you have not chosen for that role. If you have more than one child and you're choosing one child, your physician, so on and so forth. And then I mentioned in the beginning about revisiting, but it bears repeating. Just because you have an advance directive now doesn't mean you shouldn't revisit it, and think about the issues that are raised around healthcare and outcomes and COVID, and make sure that your directive accurately reflects what you would want in this situation. Next slide. The next slide is just a screenshot of information you can find at the Department of Health, and there's a website there hidden in the blue. It's not easily seen, but on that website you can find more information, and you can find a form that the state has approved both for an instruction directive and a proxy directive. Next slide. And the next slide are some advanced care planning resources, the Conversation Project, 5 Wishes, some others. And I would, I've used 5 Wishes for years with clients. I think it's a really helpful way to walk through the process, but all of these websites provide information where you can read, where you can think, where you can journal a little bit about your values, goals, and priorities. And then some of them contain forms that you can use should you wish to use a form that is less legalese and less formal than the one that's on the state's website. And of course, you can also always go see an attorney who can help you execute this document. And with that, next slide. With that, I think I'm turning it over to Michael, who's going to talk about POLST.
Thank you. Gwen, can I just jump in 1 second? I just wanted to remind people to put questions in the chat if they have questions as we go along. We are going to get to all of them at the end, but right now there's just one. So can I throw that out to you right now? Someone is asking what defines mental capacity. And that was in your slide earlier.
I apologize.
I'm sorry.
I apologize. I was speaking with the mute button on. Hopefully you can hear me now. So I think this question is about an adult who has mental capacity to execute an advanced directive. And that would be somebody for whom a court has not determined that the person lacks capacity and appointed a guardian, unless somebody otherwise challenges the situation. Decision-making capacity that triggers the healthcare proxy is a different standard. I can talk about that at the end if people want me to.
Okay. All right, thank you. So we're ready to talk about the practitioner orders for life-sustaining medical treatment, and I'll turn it over to Michael.
Thanks, Jill. Thanks, Gwen. So we've got up on the screen the POLST. You're going to hear that commonly pronounced as POLST. Stands, like Jill said, for the physician's order for life-sustaining treatment. In this segment of the webinar, we're going to cover some of the basics of a POLST. What is it? When should it be used? Who writes one? Where does it actually work, or where does it take effect? And why would you want a POLST if you already have, followed Gwen's advice and prepared yourself advanced directives? Next slide, please. Here's an image of what a POLST might look like. I've also got a citation to New Jersey's POLST statute there on the left. But generally, a POLST is a one-page medical order. It's preferably on brightly colored paper. It doesn't have to be. It doesn't have to be green or even colored at all. It's just fine if it's on white paper. But using green helps it stand out. And the general directive in New Jersey is to use green, so that way somebody could, if they're flipping through your medical file, find one of these pretty quickly. Helps it stand out from some other documents that are going to be in there. A POLST describes your goals of care, your desire for any kind of life-sustaining measures or other medical interventions. And to kind of get our minds wrapped around what a goal of care is, it answers the open-ended question, what are your hopes for the future? So for somebody who's talking about end-of-life planning, they might want to, for example, live as long as possible. Maybe they want to make it to a wedding or to the birth of a new family member. Maybe they want to be able to pass away with minimal pain or minimal discomfort. The point of this document is to document those wishes and make it possible when you're reaching the end of life to have those wishes carried out by your medical treatment team. So it may also document specific things like medical interventions, specific treatments like antibiotics, intubation, surgery, artificial nutrition, CPR. And the presumption on this form is that if you don't fill out a section, that you, the patient, want full treatment. Patients can also use this form to appoint a surrogate or to modify or revoke a POLST. They can appoint a surrogate who can then go ahead and modify or revoke the POLST in consultation with the patient's physician should the patient lose the capacity to go back and modify it themselves. Next slide, please. So the next question, when is a POLST used? Because a POLST are active medical orders, that's most useful when someone is in or is about to be in an end-of-life situation. You wouldn't necessarily execute a POLST if you were healthy and young and had a long life in front of you still. It would make more sense for you to be thinking about a POLST if you're coming up on a major surgery, maybe you've received a terminal diagnosis, or maybe you're having medical interactions with your doctor and you've got really strong preferences about your own treatment that you really want to document for immediate use should it become necessary. A POLST should be revisited anytime there's a change in status, change in prognosis, a change in care setting. Maybe you've gone from the hospital to a nursing home, or you've been discharged from a nursing home back to your own home. Or maybe there's been a change in your wishes. You've rethought what you want for yourself, and it's time to make sure that your POLST accurately reflects that. A patient always has the right to revoke a POLST at any time and for any reason, as long as they have not lost decision-making capacity. And we're going to get into decision-making capacity a little bit more, I think, at the end when we talk about questions. Because a POLST is active medical orders, it's prepared with you and your doctor. Or it can be an advanced practice nurse. And this is always prepared in a medical setting in consultation with the patient themselves. A lawyer can't prepare a POLST for you, and an individual can't prepare one on their own. It needs to be a doctor or advanced practice nurse in consultation with the patient. Again, this kind of makes sense because POLSTs are medical orders. The same way your lawyer couldn't order you a blood test or a prescription, your order can't put together medical orders in a POLST. Next slide, please. So a POLST works, in New Jersey at least, all over the state, and it applies to any medical provider in the state. Since we're not talking about what other states do, and since I'm not licensed to practice in other states, I don't want to talk about their rules, but many states do have recognition of out-of-state POLSTs. So let's say, for example, you executed a valid POLST with your doctor, and it says that you don't want to be transported to a hospital. That's one of your specific medical orders. The ambulance squad who responds to a 911 call and comes to find you at home, you show them the POLST order on this green sheet of paper, should respect that order. Similarly, if you're transferred from a hospital where you finished the POLST with your doctor there, transferred to a nursing facility for rehabilitation, the POLST would come with you, be transportable, and come with you, and still remain in effect. Everybody should respect all of the orders that are contained in the POLST. In fact, healthcare providers in New Jersey can be penalized if they intentionally disregard the orders that are found on a POLST. So it comes with a little bit of bite. Next slide, please. So if you've already gone through the advanced planning, you've prepared yourself an advanced directive, maybe you've even designated a healthcare proxy, why would you still need to talk about a POLST? You may remember the Ortega commercial from a couple of years back. Comes with a cute little girl who's got a great saying, why not both? And just like crunchy and soft tacos, every adult really should have an advanced directive in case of sudden incapacitating emergencies. But also if you're approaching a time when you might become incapacitated and it's really coming upon you, or you need to make concrete plans for your end-of-life care, the POLST can take your wishes that you've documented in an advanced directive and convert them into actionable medical orders. In fact, when New Jersey drafted its POLST laws, the legislature specifically envisioned that a POLST would work hand in hand with advanced directives. So that way, healthcare providers would be able to carry out specific orders that reflect the patient's wishes for end-of-life care that might have earlier been documented in an advanced directive. So you can see that these two documents really work hand in hand. It's just a matter of timing when one becomes more important than the other. Next slide, please. So up on the screen, it's a pretty dense slide here, but what we've got is a comparison of an advanced directive on one green column. That's the first green column on the left, and at the end a POLST, and a couple of questions about who should be considering a different document. This is a good quick reference guide if you want to differentiate between the different types of documents that we're discussing. In the center column on the green are DNR, DNH, and DNI. It stands for do not resuscitate, do not hospitalize, and do not intubate, respectively. I'm going to leave this here without going through it bit by bit because it is a pretty dense slide, but it's good when you go back, and we will share our slides with the participants and try to make them available on our website after the presentation. This is a good one to go to for a quick reference if you're trying to figure out, what should I even be looking at? There are a couple items that I do want to highlight here. And Gwen had mentioned how all advanced directives in New Jersey are springing, meaning that the contents don't become effective until you lose capacity. Unlike an advanced directive, a POLST is effective immediately. It's a medical order that your doctor has signed. So that's something to keep in mind, is that it's not something that's going to be sitting and waiting for you to lose capacity. If your doctor's ordered no CPR, that means no CPR. That's why it's important to review it and make sure that it reflects your wishes accurately. Another important thing that a lot of times folks will look to a POLST is that it's operational in the field. That's the second to last row here. Meaning that if you're at home and you prefer not to be transported to the hospital, and that's been documented on your POLST, a POLST is operational in the field, and the healthcare providers, in that case the ambulance squad, would have to respect the medical orders on your POLST. Again, I'm not going to go through this whole thing, but it's good to refer to if you need to differentiate between the different types of documents. With that, I'm going to hand the mic back to Jill. And on the next slide.
Okay, thank you, Michael. So moving forward in our agenda, Ryan is going to be talking about designating temporary guardians for children. And I just want to remind everyone that if you do have questions, feel free to put them in the chat box and we'll address them at the end. So I'll turn it over to Ryan now. Thank you. Slide.
Thanks, Jill. Next slide, please, Mike. Thank you. So as they said, my name is Ryann Siclari, and I'm a senior staff attorney with Central Jersey Legal Services. Today, I'm going to talk to you about standby guardianships. Most of us are probably familiar with the term guardianship. When we hear that term, we typically think of a court proceeding where an adult, meaning someone over the age of 18, is determined incapacitated, meaning they are incapable of managing their own affairs. And someone else is appointed by the court to manage his or her personal and/or financial affairs. But the term guardianship doesn't just apply to incapacitated adults. Minor children may need a guardian if their legal guardian, most often their parents, are unable to take care of him. So what is a standby guardianship, and how is it different than a traditional guardianship? Well, when we want to learn about something new, we ask the who, what, when, where, why, and how. Next slide, please. So who needs a standby guardianship? Well, the who is actually easy and very narrow. Parents with minor children, meaning under the age of 18, need to consider a standby guardianship. Often, the parent creating a standby guardianship is a parent who has a chronic condition or terminal illness. Although there's no requirement that the parent have a medical condition, we see ill people create standby guardianships most often, and we'll talk about why that is shortly, but it is not a requirement. So the more complicated question is, what is a standby guardianship? Next slide, please. In its most basic form, a standby guardianship is a written document in which a parent designates a person that they want to care for their minor child or children if the parent themselves cannot do so, either temporarily or permanently. One of the many benefits of the standby guardianship is that the parent is not giving up any of their parental rights. Where there's a normal guardianship, the parent would be giving up their rights in favor of someone else. That is not the case with the standby guardianship because the parent's inability to care for their child may only be temporary. So most often, parents are familiar with the idea of appointing a guardian to take care of their minor children in their will. The problem with that is that a will only comes into effect upon death. Should the parent become incapacitated mentally or debilitated physically, the guardianship appointment in the will doesn't help us. The standby guardianship, on the other hand, is effective either while the parent is alive, but incapable of taking care of their children due to incapacity or debilitation, or the parent has passed away. Next slide, please. So when do I need a standby guardianship? Remember a couple slides ago when I said most people who create standby guardianships have a chronic or terminal illness as opposed to healthy people? The reason is that the written document is only valid for 6 months from the date it's signed. That means a new standby guardianship document would need to be signed after 6 months and every 6 months thereafter. So it can be really cumbersome to redo the document every 6 months for a healthy person. However, in our current times with COVID-19, none of us really know, will we get it? None of us really know, well, if we get it, how are we going to react to it? Are we going to be okay? Are we going to end up in the hospital? We don't know. So taking the precaution of executing the standby guardianship appointment is useful for everyone with a minor child right now. And after 6 months, you can say, do I want to just do it again? Do I feel like I don't need this document? But it's only good for 6 months. So we'd have to make that decision at the end of the 6-month period if we do a new one or not. Next slide, please. So where can I get a standby guardianship form? Well, typically an attorney will prepare this document. It is a legal document. There are statutes and regulations that govern it. But thankfully, New Jersey has recognized the need for the standby guardianship and has made a template form available. And you can see that on your screen. I'm going to read it out loud for anybody who can hear it on the phone. It's nj.gov/news/covid19_power.of.attorney.form.pdf. And I'll put this in the chat box at the end as well, so you can have it conveniently. And if you look at the form and you're not comfortable filling it out yourself, then I encourage you to seek out an attorney to assist you. Next slide, please. So this is a screenshot of the document that you can get from the state of New Jersey. It's the first page, and it's about 4 pages long in total. And you can see it simply offers blank spaces for the parents to complete. About halfway down, you see alternative caregiver listed. This is the person who you are choosing who could care for your minor child if you cannot. They call it the alternative caregiver. Next slide, please. So why do I need a standby guardianship? Well, we want to make sure a minor child is cared for while not taking away any parental rights from a temporarily incapacitated parent. And as we discussed before, a will does not come into effect unless you pass away. So if a guardian is needed, whether temporarily or permanently due to a parent's incapacity or debilitation, we need a different document in place, and that's the standby guardianship. A will appoints a guardian at death. A standby guardianship is incapacity, debilitation, or death. So if you do not have the standby guardianship in place and you're unable to take care of your children, the Department of Children and Families may need to get involved and take custody of the minor child until an appropriate caregiver can be located. In that case, you are not the one making the decision. The Department of Children and Families and the court are going to decide who can take care of your children. Even then, that person would not be able to act immediately on your children's behalf. They would need to go to court for the ability to actually make the decisions on behalf of the minor through a traditional guardianship proceeding. Next page. So we're on the how. How do I sign a standby guardianship form? I put the signature block from the sample form on the screen here. And on that sample form, you'll see there's a place for both parents to sign. And ideally, both parents would sign the form as long as they are alive, have capacity, and have not had their parental rights removed by the court. If the parents are not physically together, then they can sign two separate signature pages. And you'll see there's also a place for two witnesses to sign. This is the minimum to have a valid standby guardianship. The parent must sign in the presence of two witnesses who must also sign. And just so you know, the sample form does provide a place for a notary, but the statute does not require a notary. It just requires two witnesses. But if you have the ability to have it notarized, there's no downside to it. But unlike the healthcare directive that can be two witnesses or a notary, the standby guardianship statute is very clear that it's two witnesses. So look, you may be saying to yourself, how can I sign before two witnesses in this time of social distancing? And I know Gwen talked about this in her section. I'd really like to just hammer it home here. We can't do witnessing over video. It must be in their presence. So, you know, one recommendation is maybe you have a neighbor stand outside the window and peek in and watch you sign through the window, or sit in your car with them peeking in the window. Then you stick the form out the door or out the window, they sign with their own pen. You know, there are ways to do it and still be safe about it. And as Gwen said, the New Jersey legislature did enact the remote notary law, which allows remote notarization over digital technology like Zoom, but it doesn't allow for remote witnessing. They have to be in the signer's presence. Next slide, please. So again, on how does the standby guardianship work? This is the nuts and bolts piece. The standby guardianship document will list specific events which trigger the standby guardianship. In other words, the parent must become either mentally incapacitated, physically debilitated, or pass away before the appointed standby guardian has any authority to act on behalf of a minor child. So it's springing, in other words. It springs into effect upon one of these three events. This is not a situation where they have the ability to act on behalf of the minor child immediately upon signing the document. So as Michael said, the POLST is effective immediately, but this document is not. It is springing. So step one of the triggering events occurs: incapacity, debilitation, or death. The standby guardian would need a written letter from the parent's physician stating their incapacity, debilitation, or they would need a death certificate. The standby guardian needs proof of the triggering event before they can act. Step two, upon proving the occurrence of the triggering event, the standby guardian can then begin acting as the guardian for the minor child. This part is critical because the standby guardian can act immediately without any further action on their part. That is not like a traditional guardianship. But step 3 is within 60 days of assuming guardian duties, the standby guardian must file with the surrogate court to become confirmed as the guardian of the minor child. So again, they can act without any further action for 60 days. This is critical because under traditional guardianship, they cannot act until the court proceeding is concluded. So standby guardianship, act immediately. Traditional guardianship, wait till it's done. And the reason that we can get this standby guardian to act temporarily, because the parent may recover within 60 days. The whole idea of this is that it would be a temporary incapacity or temporary debilitation, and we don't want to remove the parent's rights during a temporary medical situation. Next slide, please. So, in summary, we came together to talk about this standby guardianship. We wanted to learn the who, what, when, where, why, and how. So who needs a standby guardianship? Parents with children under the age of 18. What is a standby guardianship? It is a document appointing someone to care for your minor child in the event you cannot due to incapacity, debilitation, or death. When do I need a standby guardianship? Now. Even though you may not have a medical condition that leads you to believe you may need this in the next 6 months, COVID-19 is a crisis that makes the appointment necessary for anyone with a minor child. If it expires in 6 months, do a new one, but draft one now. Where can I get the standby guardianship form? As we said before, there's a blank form available from the state of New Jersey. It's a great place to start if you don't have an attorney that you can turn to. But remember, if you feel like you aren't able to complete this on your own, I do suggest that you reach out to an attorney for assistance. Why do I need a standby guardianship? You need to give legal authority for someone to care for your child so they can act immediately, and so the Department of Children and Family Services and foster care are not needed for your child. How do I sign a standby guardianship? You complete the designation form and you sign it in the presence of 2 witnesses. And that concludes my piece on standby guardianships. I'll turn it back over to Jill.
Thank you, Ryan. So some final considerations are to be prepared. Now that you've had these documents written up, you want to keep them in a safe place. Keeping them or storing them with your attorney or asking a friend or relative to hold on to them for you are good options. You can consider a safe or fireproof box. And of course, you can always store them digitally, but you just want to be sure that the online platforms you choose have the appropriate security software to ensure that your documents are kept safe. However you choose to store them, you want to also consider how easily you can access them when you need them. So it's a good idea to have an emergency plan or preparedness plan. If you or your loved one has an emergency, has to go to the hospital, you want to be sure that there's information accessible to the first responders and the hospital staff that explains your specific healthcare needs and advanced healthcare decisions. An excellent resource that we found is at communicationfirst.org. They have a COVID page with printable documents that you can fill out and have ready, along with any copies of healthcare directives that can go with you or your loved one in the event of an emergency. And you can also access their communication rights toolkit from our DRNJ COVID page. So with that, let's take a look. We've got some questions coming into the slide, into the chat box. So do we have the next slide for questions?
So Jill, well, While that's happening, this is Gwen. Can I just go back and tweak my answer a little bit from before? And if anybody else wants to jump in, I didn't mean to be trite. You know, the question was about an individual having the mental capacity to execute an advance directive and does so, right? So that's what the statute says. The statute doesn't define that. And so I'm really taking the position that unless a court has declared somebody to lack capacity through a guardianship order, and even then it could be a limited guardianship order, the court might find that they do still have the capacity to do an advance directive, that you can do it unless somebody challenged you. But I didn't, you know, I didn't mean to be dismissive of that if I was a little bit.
And I threw it to you off the cuff. I know we were going to save them all to the end, but there was only one in there. So that's my fault too.
There's a different, but I said I would say, so there is a definition though for decision-making capacity, right? So in the sense that advance directives are springing when somebody no longer has decision-making capacity as determined by the attending physician, so on and so forth. That does have a definition. I will read it. I'm not sure it clarifies anything, but this is what the law says, that the individual's ability to understand and appreciate the nature and consequences of healthcare decisions, including the benefits and risks of each and any alternatives to proposed healthcare, and to reach an informed decision. I want to point out again that that can be a particular decision. It isn't necessarily every decision.
Okay, thanks, Gwen. There's two questions in the chat about standby guardianships for an adult with developmental disabilities or an adult disabled child.
Yes. So I'll go ahead. I see the questions. So this is Ryan again. So the answers to your question are, there is no ability in the standby guardianship statutes to appoint a standby guardian for someone over the age of 18. And I think the reason for that is because if you have an adult who is disabled, I think the legislature believes you should probably at that point have a traditional guardianship in place, which hopefully will have those safeguards as part of that guardianship rather than needing the standby guardianship. So the short answer is no, you cannot do a standby guardian for an adult. The long answer is you should probably have a traditional guardianship if that person is already disabled.
Thank you. There's a question, can a disabled adult with a legally appointed guardian have a DNR, DNH, DNI, POLST, or advance directive, and does it need to be signed by both the individual and their guardian?
So Jill, this is Gwen. I'm going to take the part of that about the advance directive, and I'll throw the POLST part back at Michael. I don't know that I have, I think I have an answer to that, but I'll throw that back to him. The answer about an individual with a guardian is it depends. It depends on what the guardianship order says. So we can have a general or a plenary guardianship of the person or the estate, or we can have a limited guardianship of the person and estate. And so it depends what the judge wrote into the order of guardianship, whether or not the judge allowed the individual to retain that decision-making authority. I would say that I don't want to overgeneralize, but in plenary guardianships or general guardianships, in other words, where all the authority is given to the guardian to make medical decisions to begin with, there wouldn't be a purpose for a legal advance directive. But the law clearly says to the guardian, you should be making decisions using substituted judgment, right? So you should be looking at you should consult with the person who's subject to the guardianship, find out what they want, what are their goals and preferences and wishes in these situations, and your decision making should be informed by that. So you shouldn't be acting in a way that is really contrary to what those wishes are, even for a person who's incapacitated. And the one other little thing I'm going to say about this is there's sort of the corollary to that question is, if somebody has been appointed the guardian, does that mean that the healthcare representative no longer has legal authority? And the answer to that is no. The statute's very clear. They retain the legal authority to make the healthcare decisions unless the guardianship order specifically says otherwise.
Yeah, Gwen, this is Michael. So that's a great point. Is the law in New Jersey is really slated as if somebody had executed an advance directive or had appointed a healthcare power of attorney and then subsequently become subject to a guardianship because they become incapacitated. You can imagine a scenario where maybe someone's in a car accident and has a brain injury and become incapacitated and have a guardian. We should always be looking to what that person would pick for themselves. And if they wrote that down in a legal document and that's available, that's a great indication of what that person would pick for themselves. When it comes to a POLST, I think the answer is yes. A guardian, if they've got the power in the order that appointed them, would be able to enter into a POLST with the individual's physician or advanced practice nurse. The same way with a DNR, DNH, or DNI order. In fact, I think it depends on the guardianship order, like Gwen said, if those rights were given to the guardian or if they were retained in a limited guardianship with the incapacitated individual. But assuming it's a plenary guardianship, I think those would be powers the guardian would have.
There's a question in the chat box. Can a standby guardianship be revoked before the 60 days?
So this is Ryan again. Yes, a standby guardianship can be revoked, and like many documents, there's really two ways to do it. You can do a new one that specifically states any prior standby guardianships are being revoked by this new one, or you can sign a separate document stating it's a revocation of a standby guardianship and not put a new one in place.
And I'll just add to what Ryan said, the general concept in all of these things is, and then you have to give copies of all of those documents, revocations, changes to everybody, right? So if you put it in a drawer and nobody knows it's there, it can't have legal effect.
Correct.
So make sure you convey that to the people who need to know it. And you probably can hear in the background, my dog is agreeing with me right now. He's barking to affirm what I'm saying.
So that's a good segue, because there's a question asking if copies of these documents are acceptable, or do you have to present the originals?
I have to say, I'm going to defer to my other folks on the phone. So for example, with a will, it has to be the original. But with an advance directive, I'm not 100% sure. I'd have to go look that up. I reread for the millionth time the statute again, and I don't remember seeing that in there anywhere.
So this is Ryan. I believe an advance directive a copy is valid, which is why I typically recommend making sure your physician has a copy in their file. So that way, if something should happen to you and they can't locate the original at your house, the physician already has one in their file that they can send over to a hospital.
Thank you. So a few of these questions seem to be asking what I guess the best option is for guardians if standby guardianships are not available for guardians of adults.
Let me pop back in and clarify that, because I did see a couple follow-up questions. I just didn't want to interrupt the flow of your question and answer here. So when I said that it would be typically addressed in the guardianship itself, most often it means there's a co-guardian. That way, if one of the guardians becomes incapacitated because they're older or they're having health issues, then the other co-guardian could continue to act. So unfortunately, there is no standby guardianship equivalent for adults. It just doesn't exist. So if there's an advocacy position that might be taken, that might be something that we try to address in the future.
Great. So thank you. I don't see any more questions coming in. So now's a good time to remind people, if you still have outstanding questions, to go ahead and put them in the chat box as we're coming up on time. We're actually over time. Looking at the clock. So
I'll just follow up on the last question, which I think that this is Gwen, that Ryan addressed, but just to kind of laser in a little bit more. Somebody is the guardian, and the question is, if I become incapacitated, then who would take over for this individual's adult child who has severe intellectual disabilities? And the answer to that is, if it's not in the, if there isn't a co-guardian or an alternative guardian named in your guardianship order, it's probably a good idea to go back to court to get that done. That's a difficult thing to do right now, and probably something you'd need to consult an attorney about, because how difficult it is to use the court system at this point. But that would be the mechanism.
thank you. I do want to remind everybody that the presentation slides and recording will be sent out to all the participants. And Mike, will it be on the, Mike Murata?
Yes, hi. I was
Sorry.
muting also. I was
Sorry.
talking in the air when no one could hear me. Yes, so what we'll do is we'll post the recording of today's webinar on our assistive technology YouTube channel, and we'll make sure we send the link to everybody who registered today, along with the link to the slides.
So many thanks to Gwen and to Michael and to Ryan for all the information. Lots of positive feedback in the chat. And that will do it. Have a good night, all.
Thank you all.